Okay, welcome to this. This is going to be a video dealing with the 1974 to 75 grand jury of the United States versus Jeffrey R. MacDonald for the murders of his wife, Colette MacDonald, Kimberly, age 5, and Kristen, age 2. It's going to be a recreation of some of the testimony done with audio and voices, and I'll be using some AI programs to do dialogue, but I will be doing the impressions of Victor Woerheide, which probably will be crap, but that's okay. I'm envisioning Andy Griffith from the movie Fatal Vision, and my Jeffrey R. MacDonald is basically trying to sound like Wesker from Resident Evil, the original, from 1996. I will be doing voices for Freddy Kassab. I'll try to maybe do Paul Stombog too. But those will be the ones that will be covered the most, those testimonies. The rest of them will just be excerpts from the testimonies, like I did for the Article 32 hearing. But the first person they brought forth was Jeffrey R. MacDonald to testify, and he testified for 5 days. He did 5 days a piece of testimony to the lead prosecutor, Victor Woerheide. Okay. United States versus Jeffrey R. MacDonald, Eastern District of North Carolina Grand Jury, Day 1, August the 12th, 1974. The government counsel consists of Victor Woerheide, Thomas P. McNamara, a U.S. attorney, and James T. Stroud, Jr. Justice Franklin Dupree, the judge, was the presiding judge. Will you state your name, please, sir? Dr. Jeffrey Robert MacDonald. Where do you live, Dr. MacDonald? Huntington Beach, California. Dr. MacDonald, this is a federal grand jury investigating possible violations of various criminal statutes which are a part of the United States Criminal Code. These violations include perjury, subordination to perjury, obstruction of justice, murder, and assault on a government reservation. This is an investigative grand jury. This grand jury has conducted an investigation to ascertain whether, in fact, during the course of an investigation conducted by the CID, the MPs, and the FBI at the beginning of the 17th of February 1970, there were criminal misconduct on the part of any and all personnel in the investigation or involved in the Article 32 Board of Inquiry, the proceeding that resulted from that investigation. It is also investigating to ascertain if it is possible to ascertain at this time who committed the murder with respect to Colette MacDonald, Kimberly, and Kristen MacDonald, and who committed a felonious assault on Captain Jeffrey R. MacDonald on a military reservation where the federal courts have jurisdiction to inquire such matters. Now, as you know, there are a number of possible suspects with respect to each of these offenses. With respect to perjury and possible obstruction of justice, certain individuals have been appointed in the past. With respect to the murders, the finger has been pointed at various individuals and one of the other persons who has been a suspect in the past and must be considered a suspect for the purpose of the grand jury proceeding is that you yourself, since you are the only survivor of the incident that occurred on the night of 16th and 17th of February 1970, and that no one up to this point has been identified as to committing the murders, person or persons that committed the murder or the assault on that occasion. Now, under the circumstances, in view of what I just told you, it is my duty to inform you you have a constitutional right to refuse to answer any questions. If you believe that a truthful answer to that question may in any manner tend to incriminate you. Further, you have a right to counsel. You may not have counsel in the grand jury room during the course of the grand jury proceedings, but you have a counsel nearby, and upon request, you may leave the grand jury room and consult with your counsel to any matter that is asked of you during the course of the grand jury inquiry. Do you understand what I have stated to you, sir? Yes, I do. Do you have counsel? Well, yes, I do. What's his name? Bernard L. Segal. Is he here at this time? Yes, he is. Do you know where he is, sir? He's in an adjacent room, sir. I would like to request that he be allowed to be in the room just to hear the testimony. Nah, Dr. MacDonald, that isn't permissible under the federal criminal rules. He may not be in the room. The only persons that are permitted to be in the room are the members of the grand jury themselves, the government attorneys who are working with the grand jury, the official reporter of the grand jury, and if necessary, an interpreter. But I take it that you don't need an interpreter, sir. No, sir. But counsel is not permitted in the grand jury room. This would not be for the purposes of raising objections or a matter of saying anything, but just to hear the questioning. You may consult with your attorney, and you may recount to him, once you leave the grand jury room, what happened during the time that you're in the grand jury room, but you're not permitted to present during the course of the grand jury investigation. Have you discussed this with Mr. Segal? At some length, sir. Did he tell you that you would not be permitted to appear before the grand jury while you were in the grand jury room testifying as a witness? Yes, he said that was probably the case. So, you're not surprised by what I'm telling you? No. Now? Are you going to start questioning me now? Yes, sir. May I have 1 minute with them? Yes, indeed. At this time, Bernie Segal requested of Judge Franklin Dupree a motion hearing, which was taken in the courtroom. Present at this hearing was Judge Dupree, and the counsel for the government, Victor Woerheide, Thomas McNamara, and James T. Stroud. Also present was counsel for Jeffrey R. MacDonald, Bernie Segal, and Michael J. Malley.
The court recognizes Mr. Segal, counsel for the witness called to testify before the grand jury.
Yes, Your Honor.
I understand that you have some motions to make, and I'll hear you.
Does the court desire me to speak from the counsel table?
Yes.
Okay, thank you, Your Honor. If Your Honor please, the witness whom I represent is Dr. Jeffrey R. MacDonald, who was summoned before the grand jury this afternoon, shortly after lunch. At that time, Mr. Woerheide, the attorney for the Justice Department, now one of 3 counsels here for the government, made certain statements in the nature of advice as to the defendant's rights in connection with the grand jury proceedings.
Your Honor, may I point out at this juncture, there is no defendant. This is simply an investigative grand jury proceeding. There is no defendant before the grand jury.
I had understood that. There is a witness, and Mr. Segal represents this witness. Is that correct?
Yes, sir, Your Honor, and I understand that also, and had made no reference to any defendant.
All right, sir.
I did say that Mr. Woerheide had advised Dr. MacDonald of what purported to be certain rights that be applicable in the proceedings, such as being held here today. In response to those sworn statements or warnings, I will, if you will, Dr. MacDonald advised the government's counsel that he wished to the presence of his attorney, myself, in the grand jury room during the proceedings. He also explicitly stated at the time that he recognized that only for the purpose of hearing this testimony and not for the purpose of objecting or raising any questions of this sort. There follows another colloquy, which I would like to discuss in a second. Mention that I will defer at this time. Dr. MacDonald was advised at the point by the government's counsel that they would not accede to his request for my presence in the grand jury room at that time. At that point, there followed a conference between the counsels for both sides, where the government reiterated its position, and furthermore the government rejected an alternative suggestion which I think might have accommodated and or obviated the issue. At that point, we requested a right to appear before the court. Your Honor, on behalf of Dr. MacDonald, the witness before the grand jury, I am requesting that he be given the right to have his counsel present during the taking of his testimony only in these proceedings. Be clear. First of all, if your Honor pleases, I am not asking for the right to represent Dr. MacDonald during the grand jury proceedings, because I recognize the case. I recognize full well the cases which have held to this juncture. The defendant does not have the right to be represented. That is not what we have asked for in this court or the government at this time. It is to take the rights to my presence to hear firsthand my client's testimony before the grand jury, and that is necessary. Your Honor, not so that I might represent him, but I might fulfill, and the defendant may have fulfilled for him, the Sixth Amendment right under the United States Constitution to the effective assistance of counsel. That is, if your Honor pleases.
You spoke of him that in terms of defendant. I understand that he is still a witness.
Forgive me, Your Honor, I must state for the record that 4 years ago, Dr. MacDonald was the defendant in a full military court proceeding uncovering almost the identical issues, at which, at the conclusion of the longest military hearing of this sort ever held, the military grand jury concluded there was no legal or factual basis to accuse him. Unfortunately, am unable to shake that from my memory. But I am talking about him in the role of a witness. My point is, if Your Honor pleases, that representation which is prohibited and to which we acquiesce to be the standard of the law would involve the right to question, to perhaps offer evidence, and to participate in the proceedings. This is not what the defendant asks in this case. But the defendant has the continuing right under the Constitution. The witness has the continuing right under the Constitution at all times, if Your Honor pleases, assistance of counsel. He cannot in this case because of the anticipated length of the witness's testimony before the grand jury be effectively achieved by having the witness come out after each question and attempt for a layperson to recite the questions that were put to him, so the counsel may at least know what is being asked. Secondly, it is even less possible, feasible, or desirable to have the witness come out from the grand jury after each answer, and for the benefit of the counsel to repeat verbatim the answer, and yet absence my opportunity to simply want what my client, the witness, being asked what witness is answering. And yet, absent my opportunity to simply know what my client, the witness, is being asked, what the witness is answering, I cannot render the constitutional guaranteed right which goes on outside of the court ongoing, and throughout these proceedings, and in any related matters, I cannot provide him with effective assistance or counsel, and in this case, the assistance of counsel requires in my judgment. Your Honor, it requires in the witness's belief and judgment the right for his attorney to be present. There are some special circumstances which further highlight the necessity for this assistance. The subject matter of the grand jury, if Your Honor pleases, deals with an episode that took place some 4 years and 5 months ago. That without a doubt was a long time to bring a witness in and ask the witness to go over in great detail, which is necessary and desirable to further this investigation, all the facts of that episode. We fully expect, upon being advised by government counsel. Forgive me, Your Honor, I must state for the record that 4 years ago, Dr. MacDonald was the defendant in a full military court proceeding covering almost the identical issues, at which, at the conclusion of the longest military hearing of this sort ever held, the military grand jury concluded there was no legal or factual basis to accuse him. I unfortunately am unable to shake that from my memory. But I am talking about him in the role of a witness. My point is, if Your Honor pleases, that representation which is prohibited and to which we acquiesce to be the standard of the law would involve the right to question, to perhaps offer evidence, and to participate in the proceedings. This is not what the defendant asks in this case. But the defendant has the continuing right under the Constitution. The witness has the continuing right under the Constitution at all times, if Your Honor pleases, assistance of counsel. He cannot in this case because of the anticipated length of the witness's testimony before the grand jury be effectively achieved by having the witness come out after each question and attempt for a layperson to recite the questions that were put to him, so the counsel may at least know what is being asked. Secondly, it is even less possible, feasible, or desirable to have the witness come out from the grand jury after each answer, and for the benefit of the counsel to repeat verbatim the answer, and yet absence my opportunity to simply want what my client, the witness, is being asked, what the witness is answering. I cannot render the constitutional guaranteed right which goes on outside of the court ongoing, and throughout these proceedings, and in any related matters, I cannot provide him with effective assistance or counsel, and in this case, the assistance of counsel requires in my judgment. Your Honor, it requires in the witness's belief and judgment the right for his attorney to be present. There are some special circumstances which further highlight the necessity for this assistance. The subject matter of the grand jury, if Your Honor pleases, deals with an episode that took place some 4 years and 5 months ago. that without a doubt was a long time to bring a witness in and ask the witness to go over in great detail, which is necessary and desirable to further this investigation, all the facts of that episode. We fully expect, upon being advised by government counsel and based upon our experience in the military grand jury proceeding in which this witness testified at length under oath and under cross-examination, that his testimony took then a day and a half. We are being asked, if your honor pleases, to provide the effective assistance of counsel to Dr. MacDonald without knowing and being able to counsel him based upon the questions and answers being put to him. You have the delay of 4 years as being a serious impediment to his memory. But secondly, it isn't with just an ordinary memory that you are dealing with. The subject of this grand jury is the slaughter of the witness's family and the near fatal assault upon the person by a group of individuals. And that slaughter is a matter, and I do not think it requires much for any of us to appreciate, is not something that one is able to live with easily, except trying to accept the reality, but not trying to make it the only and ever-present issue in one's life. It is, in fact, the kind of thing that one has to accept to put back a little so one can go on in life. The government now, 4 years later, wants this witness to remember 4 years ago, to deal with the deep emotions of the slaughter of one's family, and at the same time deny him the right of his attorney to simply appear all the things that are being asked, to simply hear all the things that are being asked be dredged out of his mind. Not to interpret, not to question, not to participate, not to represent in that word which is prohibited to him, but to have my assistance. Seems to me that these are special circumstances. Those are the circumstances, and those are require my judgment, Your Honor. The simple relief of permitting me to hear what is going on. I want to submit to you, Your Honor, that it is within your power, it is within your discretion. If it is not, in fact, the matter of the right, it is certainly within your discretion under the rules to allow this to take place. There is no other case, and there is nothing in Rule 6D which prohibits it. It merely authorizes it if Your Honor pleases. The government has the right to be present and represented in the grand jury proceeding. That is their right to have a stenographer, and it does not make that exclusive, nor does it prohibit any other persons from being present. The cases that have talked about that issue are the defendants who have appeared, not the witnesses, not the witness, or even the witnesses who have appeared, who have all asked to have counsel, have all dealt with a different issue. That is those persons that wanted to be represented, and we say that we are asking for here is not representation that represents the argument and my request at the time, Your Honor. I do have a second motion. That is, those persons that wanted to be represented, and we say what we are asking for here is not representation. That represents the argument of my request at this time, Your Honor. I do not have a second motion, but I think perhaps best that I can delay that until perhaps you hear the government's response.
Very well.
If Your Honor please, when you charged the grand jury this morning, you told them of the secrecy element that surrounds them. I reminded them of that when I went to the grand jury room. We go back to Rule 60, and it specifically says who can be in the grand jury, and it does not say an attorney for a witness. It says government attorneys, court reporter, the witness, himself or herself. We are merely operating under a federal statute that Congress has established, and there are many cases. You can pick out Wright's book on procedure that we have here, and find many cases supporting that position. We had this very point come up in a case of ours. It is not a reported decision, where Judge Larkins wrote, William Worthington Russell, the fourth, the counsel for the witness before the grand jury asked to be present during the testimony of his client before the grand jury. Judge Larkins ruled that he cannot be present. This is just June 10th, 1974. I have a copy of this order here, and I will be glad to hand it up to you.
I don't need to see it. He didn't have these special circumstances that Mr. Segal called attention to.
I don't think there are any special circumstances. Time has gone by, but surely this witness, if he has been through this procedure before, has gone back and reviewed his testimony now that he gave at the Article 32 hearing. It is not unusual that the man can't recall what occurred on the events. He is one of several witnesses that we intend to call before the grand jury. He probably will be able to aid the grand jury. Now, if we allow him to have his counsel, we will have everybody calling for attorneys to go in before the grand jury. Granted, Judge Larkins probably didn't have.
He doesn't want to counsel with the man, though, or represent him, or cross-examine the witness. He just wants to hear. He just wants to hear firsthand.
But that violates the federal statute. You put a lawyer in the grand jury, and the witness will be looking at the lawyer for answers, vice versa. The attorney there, it is an outside element that you are introducing into the grand jury room. I don't think that you get the true picture that we want the grand jury to see. We want them to just examine the witness, all witnesses before the grand jury. I don't think that's the true nature of the federal statutes. I am sure Mr. Woerheide has something to add to this.
All right, sir, I'll hear him.
There's no reason why Dr. MacDonald can't fully inform and fully brief his counsel as to which each and every matter that transpires here before the grand jury. We already informed him that he has the right upon request to leave the grand jury room and confer with his counsel whenever he so desires. Your Honor, if we to establish a practice in this jurisdiction of permitting unauthorized persons to appear before the grand jury proceedings would be violated. This grand jury, which at this juncture is an investigative grand jury, simply inquiring into the facts, circumstances to see if there was some criminal violation, law violation. But if this grand jury were to vote an indictment against any person as the result of the grand jury inquiry, and there were unauthorized persons before the grand jury, it'd be grounds for dismissing that indictment. And if it was not dismissed, it went to trial.
That wouldn't be so if this witness should be indicted, and that person should be his counsel who was allowed in there by virtue of a motion made for that purpose and allowed. Certainly, he wouldn't be able to attack the indictment on that ground.
The witness was informed at that time he first appeared for the grand jury, although he was a possible suspect. There are a number of other possible suspects with respect to the crime murder. Furthermore, Your Honor, we are investigating other violations, other allegations of perjury, subordination of perjury, and obstructing of justice. And if an indictment were to be returned by this grand jury, the secrecy of the grand jury would be violated. And I have no doubt that the indictment would be subject to dismissal.
All right, sir. Mr. Segal, you want to be heard further on this?
Without belaboring the subject, Your Honor, I ask for your indulgence very briefly. If the government concedes, Your Honor, that the witness has the right and that they have to concede, it has to come back out after every question and repeat the question to me and go back in and give the answer and then come out after the answer, then repeat that to me. Once he concedes that, it seems to me that the procedure of their instance that I not be permitted to hear it for myself is such an absurdity. And of course, it is called to mind that 400 years ago, lay people continued to quote Shakespeare. The law doth make an ass of itself. Why am I not entitled to hear directly? As a matter of fact, the very proof of why this procedure that I have asked you to allow this afternoon is necessary is tied to the second motion that I make, because I suspect when I state the reason for my second motion, Mr. Woerheide or Mr. McNamara will leap to their feet and deny precisely that. That is what they say that to my client in the grand jury. And we are going to have to come to an argument over what? The liability of a lay witness to come out and repeat to the counsel immediately thereafter, correcting certain statements, because I am prepared to make certain representations to Your Honor. Why should that be necessary? Why should we have to engage in this certain absurd procedure which says I am entitled to know what goes on, but not accurately? But for those reasons, sir, I submit to you that our motions must be granted.
Also, you have a second motion?
Yes, sir. That will be somewhat briefer, sir, if Your Honor pleases. During the initial questioning of Dr. MacDonald in regard to reportedly warn him of his rights conducted by Mr. Woerheide before the grand jury. At that time, Dr. MacDonald warned the government counsel that he wished the presence of his attorney. He was then asked by the government counsel whether or not he had to discuss the issue of the right of his attorney to be present in the grand jury proceedings, and whether or not I advised him in that regard to such a matter. It is that the best recollection that my late client was able to give me of that discussion, and I will submit now, Your Honor, that is totally grossly improper for the government to go into the question of what advice the counsel has given to the witness. I suspect that was more unintended than deliberate. The counsel for the government, I trust, is aware that he may not inquire as to what legal advice was given to a witness by his attorney through the course of the attorney-client relationship, just precisely.
I didn't understand you to say it was contended that they had asked the nature of the advice, but just whether or not the question had been the subject of some conversation, not what the conversation was.
My understanding, again, my problem is that I am dealing with the second-hand reputation of what the client layperson has said relates to the conversation dealt with, and he has told something about those rights by me. In effect, the question of which sought to elicit the nature of the counsel's advice. If Your Honor would indulge me for one moment, I want to refer to a note here. I think further I could further add the counsel to the record by saying apparently Mr. Woerheide's government counsel, after making some statements that I have given so far, said to the witness, so this is his decision, not to create my presence, doesn't come to surprise to you. That is a characterization stating that, of record, the nature of advice and that I have given, and that I think is grossly improper, and for that reason I would ask Your Honor to instruct the government's counsel to refrain from either directly or indirectly seeking to find out the nature of the legal advice given to him to the witness in this case. By the way, again, Your Honor, to apprehend the needless difficulty we are struggling with to understand precisely the words. If you can present, I think I can separate the difference between a general question which I can deal with this area.
What would you have done if you had been there?
I would have made notes to that effect and reviewed what area it would have gone into. I would not, and I represent this to the court, attempt to signal the witness to show any kind of emotion, any kind of feelings, any kind of signals. I am a professional, Your Honor. That is not my function. I do not behave that way. I don't think that counsel that has ever known me would have known me to do something to subvert the grand jury proceedings. I must say, Your Honor, I have been in state court permitted where special circumstances were shown to appear before a grand jury. Take the case of the Commonwealth versus Carrera and Garcia. The case ultimately went before the Supreme Court of the state of Pennsylvania. In that regard, representing the witness in the grand jury room in the proceedings for the purpose of adequately getting the witness to express her rights. The court simply thought it was expedient and desirable for counsel to present. For the time being, it served the purpose. It is not heard of in that regard.
All right, sir.
If Your Honor please, on this latter motion of counsel in regard to the impropriety on the part of the government's counsel, I emphatically deny that such did take place there. I listened as Mr. Woerheide was asking Dr. MacDonald these various questions, and Dr. MacDonald brought up the fact that he would like to have his counsel in the grand jury room. So Mr. Woerheide went ahead and asked him if he had discussed this with his attorney, this fact. He didn't ask for any type of disclosure on what they discussed, just when this particular point had been discussed. Now, if we get into a shooting match over words, we'll have to go back to the court reporter, but it did not strike me anywhere near being any question of impropriety there. So I think that motion...
Well, does the government recognize that it has no right to inquire into the nature of advice obtained by a witness or anyone else before the grand jury? Advice from his attorney? Do you recognize that?
Your Honor, we recognize that a witness who appears before the grand jury has certain privileges. One is a privilege not to testify as to any matter one might tend to incriminate him. The other privilege is a right. It is not a right, a privilege. It relates to the confidential communication between attorney and client. It is not a privilege of the attorney, it is a privilege of the client. If the client is a witness before the grand jury, he may be asked questions. He may assert the privilege. He may refuse to answer the question, but there is no prohibition with respect to asking the question.
Your Honor, if I may add one point further with regard to Mr. Segal's request to be in the grand jury room. After every question that Dr. MacDonald is asked, if he still has to confer with Mr. Segal, as he probably will, they are going to go out of the grand jury room anyway. So we are going to have so much traffic going back and forth. I can't see how anything is going to be accomplished by allowing Mr. Segal to be in there.
You don't think a logistical problem will be solved by having him in there?
I definitely don't think so. I think it would be most distracting.
If Your Honor please, I made my statement to the court in absolute good faith, and I have the advantage over both the government counsel and Your Honor, if Your Honor please, that I have participated in that fully, completely in the military proceedings that preceded. Sir, I have some intimate knowledge of the details of the case, and further I have experienced in representing the witnesses in the grand jury matters. I think I could safely and honestly hoping that the court will respect my word, say to you that I think that we will solve a substantial logistical problem by granting our first motion, that I have no reason at all to anticipate that if I am able to present that there will be needed for assisting and frequent adjournments, so that the witness can counsel with me. Perhaps, if you were to occur and did not solve the logistical problem, I see no reason why Your Honor might not want to consider your decision. If Your Honor will permit me to present, I think Your Honor would find as a practical matter that it would not be necessary, and it would obviate the government's position. I am appreciative of Your Honor in your indulgence to hear me out, but I do not think that I would be serving my client properly if I did not respond to or call attention to what I heard in Mr. Woerheide's remark. And that is that he wants an undisclosed layman to make the decision whether or not he is supposed to discuss with the grand jury and with the government's attorneys the nature of advice I gave him. And that is precisely the kind of thing that the privileges are supposed to protect. You don't give the government lawyers to ask areas that they know they can't stop in a second. And that is why I asked Your Honor to rule and not to advise the government. For Your Honor to rule and not to advise the government to not play games with fundamental rights. They have no business going into legal advice and say, well, the layperson, he can decide the way of that. That provided the witness knows enough to go out and find whether this critical area or not is simply a charade. And I ought to say to you, Honor, deal with the issue of similarity, and say the government ought to not go into the question of rights. And I am frankly surprised that Mr. Woerheide takes the position that the government can fool around with the attorney-client privilege, and see whether they can find out legal advice the lawyer gives them to a witness. That, to me, sir, is unworthy of this case.
All right, sir. Anything else?
No, Your Honor.
Not that I know of, Your Honor.
All right. We will recess until tomorrow morning at 9:30 a.m.
Okay, Victor Woerheide went back to questioning Jeffrey R. MacDonald. Dr. MacDonald, you stated your present address. Where are you employed, sir? St. Mary's Hospital in Long Beach, California. Do you have an office in that hospital or a private office? No, I'm a member of the group of 8 physicians that run the emergency department. Does it have a telephone number? Yes, it does. Now, going backward from the present time to December 4th, 1970, I think is the date of your discharge from the Army. Can you tell us the various places that you reside during that period of time? From December 4th, 1970? Yes, sir. Initially, I was at a friend's house in New Hope, Pennsylvania. I was at my mother's place in Pachagal, Long Island. Was your friend Robert Stun? That's correct. And thereafter, you stayed at your mother's house for a brief period of time. When you left your mother's house, where did you go? To an apartment in New York City. And where did you move from there? California. Did you try to occupy the quarters that you now occupy? I stayed with one of my partners, a man who is now my partner. And what's his name? Dr. Jerry Hughes. And then you moved you moved to the place you now reside. Is that it? Is it an apartment or a house? It's a condominium. Do you own the condominium? I'm in the process of owning it, yes. Now, since you were discharged from the Army, and what employment have you had, sir? I'm a physician. Specifically, you're not in private practice yourself? No, I was. You're now employed by an employer? That is correct. And who is or was the employers that have employed you since your discharge from the Army? I was a clinical physician at the World Trade Center in New York City at the Industrial Clinic for approximately 6 months. And that was in 1971, I take it? Right. The director of the clinic was Dr. Gilbert Benjamin. Dr. Benjamin Gilbert, his main office was on 45th Street in New York. I don't know the address. Who was your next employer? Essentially Dr. Hughes in California. Are you still working for him? It's not really. I don't really work for him. It's a group of physicians. It's more like a partnership. Have you been associated with the partnership since you've been in California? Yes, I have. You are a whole partner in this partnership, I take it? Yes, a junior partner of the partnership, but I am not employed by them, yes. How long did you live at Fort Bragg? The exact dates? Yes. It would have been August of 69 until my discharge from the Army, which was December 4th, 1970, is that correct? Right. Did you leave the same day? I don't remember. Now, prior to coming to Fort Bragg, where did you live? The prior few months, I was in the Army in July of 1969. I would have been at Fort Sam Houston, Texas, and in August, I was in jump school at Fort Benning, Georgia. Take it your family wasn't able to live with you while you were at Fort Sam Houston. Now, or while you were at jump school, they joined you after you were at Fort Bragg. That's correct, sir. So you were there for a period from July through August when your family was living somewhere else. That's correct. Where are they living? Pachagal. With their parents or your parents? My parents. In Pachagal, or your wife and children just visiting there? They were just visiting there while I was on my way. That was not a permanent abode for them at all. No. Just temporary? That is correct. To the time that you were in the Army? Where did you live? That was my internship. I was living in some little town in New Jersey, Bergenfield, Bergenfield, New Jersey. And were you applying and interning where at that time? Columbian Presbyterian. Prior to living to Bergenfield, where did you live? Chicago. Did you live in several places in Chicago? Yes, I did. Was that during the time that you were a student? You did live in the city proper or in the suburbs. Which one did you live in? 3 different apartments within the city. Were they in the Loop area or near the Loop? One was next to the medical school, which is just north of the Loop. 2 were a little further out of the city. And prior to going Northwestern, you were a student at Princeton University. Is that correct? That's correct. Did you live on or off campus? Off campus. Now, when were you and Colette married? September 14th, between my sophomore and my junior years. I guess it's 1963. Now, Dr. MacDonald, did you, in preparation before the grand jury here, have you gone over the records that you retained? Yes, sir. Will you tell me specifically what records you've gone over? The Article 32 hearing that was held in Fort Bragg. Do you have a complete transcript of that, sir? Yes, I do. All right. What other records? A copy held by the CID of the interrogation of me on April 6, 1970. That's right. What other records, really? You know, there were newspaper clippings mixed in with this stuff. But that was really the formal reading that I did. Do you have a file of the newspaper clippings? My attorney asked me to keep it in conjunction with this case. Did you bring any of this material with you? I have some in my briefcase. Is there any other material that you referred to? You mean other than loose papers that were associated with the Article 32 hearing? You specifically mentioned the transcript of the testimony of the Article 32 hearing? Right. Transcript of the interrogation that took place on April 6, 1960? Right. And you mentioned the newspaper clippings? Yes. Now, Niall, was there anything else? There was a lot of loose, when I was referring to the Article 32 transcript in my box. There's a lot of loose papers I looked at. What do those loose papers consist of? Correspondence? Some correspondence. Some of the court motions that we filed in conjunction with the Article 32 hearing. I don't know what they mean in interviews taken of other witnesses that the CID was badgering on Long Island, things like that. Some correspondence, some of the court motions that we filed in conjunction with the Article 32 hearing. I don't know what they mean. Interviews taken of other witnesses that the CID was badgering on Long Island, things like that. Now, what were the witnesses you were referring to on Long Island? Friends of mine, friends from the past. Can you specify these individuals? People like Harold Leon, people that I haven't seen for years and years. There is a whole lot list of old friends. There is a whole list of old friends. Can you mention any others besides Harold Leon? Carol Leon. Karen Perry. They really weren't important. This was part of the, as I was leaving. As I was leafing through this, I saw things. I'm trying to give you a full recollection. Karen Perry. They really weren't important. This is part of the, as I was leafing through this, I saw things. I'm trying to give you a full recollection. Did you have copies of any interrogations of these witnesses or such? Or did you have a memorandum reflecting the fact that they were conducted by the CID? Any certain questions? I think that there is some of those. I don't specifically read any formal statements. But the copies I have interrogations that were turned over to you by the CID, I take it? I don't know. I am a little confused. I don't know if it was them. I read MP interviews on Post. This is a great big file, about 6 years worth of reading. Do you also have a file of the transcript of interrogations by Mr. Ivory, Grebner, and Shaw by counsel? I certainly do. Did you participate in any of these interrogations? No, I did not. Is that part of the material that you referred to? No. Did you prepare material to be furnished to other persons concerning the investigation or the consequences of the investigation? Don't understand what you mean. For example, did you furnish any material to any congressmen or any government officials? Surely. Do you have any copies of that? I have copies of a press release that was issued when I got out of the Army. One of the congressmen asked me to prepare. Was that the only one? That was the one furnished to Congress. Well, is this the only document of that type? No, I have copies of the Kassab's allegations that he sent to Congress. Did any other persons make allegations and send it to any other member of Congress or any other officials to your knowledge? One of the military attorneys did. What was his name? Not to Congress, pardon me. I didn't hear the full description. Or to any official. Sure. Being Army, right. Lieutenant Michael Malley now. Yeah, right. Lieutenant Michael Malley. Officials being Army, right? Lieutenant Michael Malley. And is that one of your attorneys present here in Raleigh at this time? That's correct. Representing you and acting on your behalf, is that correct? That's correct. Now, do you have any other, let's say, memorandum summaries that you prepared for the benefit of your newspapermen? Now, do you have any other, let's say, memorandum or summaries that you prepared for the benefit of the newspapermen? I have copies of long newspaper articles, but I don't have the memorandum in preparing them. How about radio interviews and television interviews? I have copies of those. Do you have any copies of any material that was prepared in connection with, let's say, your participation in a TV program, or radio program, or an appearance that you may have made as a lecturer, as a speaker, before anybody or any student bodies or any other groups that might be interested in hearing this matter that we are discussing? No, sir. Dr. MacDonald, when you graduated from medical school, where were you admitted to the practice of medicine? I had an internship first in New York, following which I was admitted to practice medicine in New York, North Carolina, since then, California. Did you take a state board examination in New York? No, I had national boards that accepted by both states. And when you first admitted to the practice of medicine in New York, or in New York City itself? I believe the day of the license was June 15th, 1969. I think that coincides with the graduation from the internship. Dr. MacDonald, when you were admitted to the practice of medicine in North Carolina, Dr. MacDonald, when were you admitted to the practice of medicine in North Carolina? It'd be a few months later. I honestly don't know. Did you have to take a state board examination here? No, I had to appear before a medical board for the conference, essentially, in, I guess, Raleigh. I get to make copies of your credentials from New York. Correct. And while you came to Fort Bragg in August now, about when was it that you went to practice in North Carolina? I honestly don't remember. I presume it was in the fall. I really don't remember. When were you admitted to practice in California? I don't know. It was either I applied sometime when I was in the Army, because the national reciprocity runs out after 5 years after graduation from the medical school, and I applied sometime while I was in the Army, and the entire matter was handled by mail. The California application? Yes. The application that any action taken by the state board on your examination or notification of your acceptance or your licensing as a medical practitioner in California. Yes, it was. So, you didn't have to appear personally in California in order to obtain your license there? No. Mr. MacDonald, or Dr. MacDonald, where were you born? In Jamaica, Queens, New York. Did you grow up in Jamaica, Queens, New York? No, I grew up in Pachaga. And where did you attend elementary and high school there? Yes, I did. And will you tell the grand jury, please, about your school activities and your school study, any honors positions that you held, any activities such as athletics or honor society or anything of that sort? I played on the football, basketball, baseball teams, was president of my class, and was in the key club, the varsity club, the band orchestra. I was president of my class, and several other little things, you know. Was that your standing when you graduated? I guess it was top 5, 3, or 4 in the class. Something like, that. As a result of your scholastic excellence, did you get a scholarship? Yes, I did. And who awarded you this scholarship? Initially, I received 2. I received a very large one from Colgate or a smaller one from Princeton University, and I accepted the Princeton one. And what did you study there as an undergraduate? Biology. And this was in preparation for further study in medicine at a later date, right? Right. What were your activities as a student in Princeton? I worked my way to pay my. I worked to help pay my way. I was in the boxing club for a while. Some intermanual sports. Nothing very dramatic at Princeton. What was your scholastic standing at the end of your third year? It's relatively high. It wasn't super high. I think it was upper third. I think they did it in thirds at that time. I think that I was in the upper third. And did you apply at the Northwestern University Medical School? I did. It is unusual for a Northwestern University to accept in medical school students persons who do not have an undergraduate degree. Yes, but it's not really unusual. They accept more than most medical schools. They believe in it. So I was one of 134 people in the class. There were probably, I would guess, 20 or 25 of us who were there, 3-year undergraduate students. Some schools don't accept all of them. Did you have a scholarship at Northwestern? Yes, I did. Was that for scholastic excellence? Well, they say yes, but really it is for, if you don't have the need, you don't get it. No matter how smart you are, if you follow me. That scholarship continued over the period you were a student at Northwestern University School, which was 4 years. Is that correct? Right. Now, what was your family situation, Dr. MacDonald? You referred to your mother as being alive. Is your father alive? No. When did he pass on? When he was 48. I was a sophomore in medical school. Do you have any other siblings? I have an old brother who's older, and about 18 months older than myself, and my sister is younger, about 18 months younger. What's your brother's name? James. And what's your sister's name? Judy. Have you always had a good family relationship with your father, mother, brother, and sister? Yes. Have there been any problems? Sure. Have there been any family crises? Yes, there have been family crises. Have any of these crises had an effect upon your life? Yes, I lost my family at Fort Bragg. That affected my life. I'm referring to your family, consisting of your father, your mother, your brother, and your sister. Sure, my father died. That affected my mother, and it affected us. My brother used drugs, and that affected us. And my sister is mildly anxious, a young married female, and has her crises and calls in the middle of the night, but nothing spectacular. I see it's after 4 o'clock, Mr. Foreman. I know some of us have to travel quite a distance, and I know the judge said you would be excused at 4 o'clock, and I suggest that you may wish to adjourn us this time. I understand that your schedule starts at 9:30 in the morning, and if it's agreeable with your grand jurors, I'm going to ask Dr. MacDonald to be excused and turn tomorrow at 9:30 a.m. for further testimony before the grand jury.
Very well.
Dr. MacDonald was excused, and the first day of the testimony at the grand jury ended.